An update on SafeMoon. This has to do with the final hearing on motion to sell debtors operating business assets, as is posted by Live4Ford over on Twitter. Shoutouts to them as usual. This audio recording is about 18 minutes long. I'll play it for you in just a moment. There's a crypto exchange called Margex, and if you have not heard of this platform, it has some amazing features. There's no KYC, so if you want to check it out, you can get started in about 30 seconds to 1 minute. In addition, they have leverage trading, anywhere from 5x all the way up to 100x, meaning that you can try and maximize your gains. There's more risk, but there's also more reward. You can buy crypto directly on their platform. They even have copy trading, so let's say you're not that confident in your trading skills, you can see how some of the other traders are performing and mirror your trades off of theirs. And they also have staking opportunities too. If you use my referral link in the description below, you can claim up to $10,000 in bonuses. Up to. So you can work your way up. If you guys want to learn more about that, you can find my referral link down in the description below. This is available in a lot of different regions. If it's not available in your region, there are some people that decide to use VPNs to get around that. Not saying you guys should. That's up to you. And with that being said, let's go ahead and get back over here. I'm going to go ahead and play this for you guys now. And I'll see you at the end of the video.
The United States Bankruptcy Court for the District of Utah, the Honorable Joel T. Marker presiding, is now in session. God save the United States of America and this honorable court.
Good afternoon. We've got one matter in the SafeMoon US LLC Chapter 7 case. Could I get appearances, please, starting with trustee and counsel?
Good afternoon, Your Honor. Ellen Ostro, Chapter 7 trustee.
Good afternoon, Your Honor. Jeff Goodman, Foley & Lardner on behalf of the trustee.
Ms. Wilden?
Melinda Wilden for the United States trustee.
Ms. Schur?
Good afternoon. Therese Scheuer for the U.S. Securities and Exchange Commission.
Good afternoon, Your Honor. Mark Rose appearing on behalf of the debtor.
And Your Honor, also on the line is my financial advisor, Peter Hurwitz of Dunn & Advisors.
Thank you. Anyone else wish to make an appearance? All right, Ms. Ostro, I've read the motion, Mr. Hurwitz's supporting declaration, the response by the SEC. How would you like to proceed?
I'll let Mr. Goodman address the court, Your Honor. I believe there's been an uploaded red line for a revised order that may address the SEC's concerns.
Yes, thank you, Ms. Ostro, and thank you, Your Honor. We did, Your Honor may have seen it, but if not, we uploaded a red line proposed form of order, or filed, docket number 164. That includes paragraphs, if Your Honor, paragraph 13 that the SEC had requested, an additional paragraph that the trustee had requested in light of that. So we've added that. I understand Ms. Schur can speak for herself that in light of the inclusion of that paragraph, that they don't have objection to the entry of the sale order. I will mention, Your Honor, I have a comment about paragraph about 16, but maybe I'll wait to, if it please the court, to ask whether this satisfies the SEC, then we can address some of the ancillary issues that impact 16 and contracts and the like.
All right. I have had a chance to review docket 164, the redlined order. Does it meet the concerns of the SEC?
Your Honor, the trustee did add the language that we requested at paragraph 13. The SEC also filed a reservation of rights to make our position clear, Your Honor. And if Your Honor will permit, I'd just like to state our position on the record at today's hearing.
Go ahead.
Thank you, Your Honor. Your Honor, the SEC filed a complaint against the debtor, SafeMoon US LLC, its affiliate, and certain of the debtor's former officers in the United States District Court for the Eastern District of New York. The complaint alleges, among other things, that the defendants perpetrated a massive fraudulent scheme that generated millions through the unregistered offer and sale of a crypto asset security called the SafeMoon token, and the defendants profited by misappropriating from the project's crypto assets worth tens of millions of dollars. Given the allegations in the complaint, we are a significant creditor and could be the largest creditor in this case, Your Honor. The staff has raised concerns with the trustee and made itself available to discuss the trustee's potential sales, but we did not learn the identity of the buyer or see the proposed APA before it was filed on the 16th. Yet, SEC filed a reservation of rights yesterday in advance of the objection deadline at docket number 161. Your Honor, what is before the court appears to be part of a larger deal to possibly restart SafeMoon offshore and a series of transactions which include the unregistered sale of SafeMoon tokens to the buyer. As set forth in the SEC's reservation of rights, the staff has concerns regarding the sale of the so-called exchange in this part one of the sale transaction. The facts and circumstances surrounding the sale, including what the buyer intends to do with the so-called exchange, have not been provided. In other cases, Your Honor, the SEC has sued crypto businesses for operating as unregistered exchanges. The SEC's reservation of rights included a cite to the Binance complaint for the SEC's views on unregistered exchanges. Again, given the allegations in the complaint, the SEC is a significant creditor, which begs the question, for whose benefit is the trustee seeking these sales when we have expressed concerns? And ultimately, what exemption will the trustee be relying on for the sale of the SafeMoon tokens in part two of the transaction? Without satisfying the many concerns that we have raised, it is very likely that we will strongly object to the proposed sale of the SafeMoon tokens. The transaction seems fraught with risk for a deal that is only bringing in $500,000 to the estate. As set forth in the reservation of rights, the SEC is not objecting at this stage to part one of the transaction. It's not objecting to part one. It is also not opining as to the legality under the federal securities laws of the transactions outlined in this part one sale, and reserves its right to challenge transactions involving crypto assets. Thank you, Your Honor.
Thank you. Mr. Goodman?
Your Honor, I'll try to hit the high points. There's a lot to unpack in that statement. I guess I'll try to hit a few big things. First is obviously Ms. Ostro as trustee and my firm and Dundon representing have been trying to maximize the assets for the benefit of creditors. We've never operated SafeMoon. Never got involved in any of the allegations that were in the part of the SEC's complaint. I know Your Honor knows that, but I wanted to state it for the record. With respect to the sale itself, there's a lot of speculation and from the SEC about what they believe the buyer's going to do. Mind you, there were multiple buyers, some, at least one of them submitted a qualified bid, and others they shed expressions of interest and might have been able to be qualified, but in the end, they weren't offering enough to try to make sure we qualified them because they weren't going to pass the $350,000. So that because these assets that are being sold as part one really can be independent of the SafeMoon ecosystem. It's a decentralized exchange that may allow facilitate trade. There's private wallets that a crypto company might want to that could offer to allow people to have custodial assets there. Wallet tracker, there's intellectual property, there are patents. It's everything we put in our original motion. We weren't sure what kind of interest we would have. We were pleased among the 600 people we reached out to that there were bids and there were other expressions of interest that weren't bids. There's a lot of discussion about the tokens in part two of the sale, but these sales are, in fact, while they're part of two APAs, they can stand on their own. Your Honor,
well, that's the question I had. That's the question I had. Are they contingent on each other?
They are not, Your Honor. The way the APA works, or the APAs, essentially the second APA, because all of the value of the tokens are in the second APA, they just don't pay the money for the. We hope we'll convince Your Honor, and we'll be convinced the SEC, and then ultimately Your Honor to approve the second sale when we bring that motion for you. We expect in the near term, on regular notice, and allow the SEC to comment. But if Your Honor ultimately does deny approval, despite our request for it, we still keep the $350,000. They still have the decentralized exchange. They still have the trademarks. They still have all the assets that we hope Your Honor will approve today. So this is a little bit of the cart before the horse, talking about what happens with these tokens when these assets, they're obviously willing to take them on, regardless of what happens in Part 2, even though we will be in front of Your Honor requesting Part 2 to get the additional $150,000. So actually, in some ways, that actually proves the case. This sale is, they aren't dependent. This isn't some SafeMoon, attempt to trick the SEC, because they're willing to take these assets on, which are 70% of the value, without any guarantee that Your Honor ultimately will approve the second sale that we'll bring forth.
Could I get a clarification? Is the purchase price in the asset purchase agreement is $300,000?
Yeah, Your Honor. So it's. And maybe in retrospect, this could have been done a little slightly differently, but what wasn't our doing, is what the buyers submitted. It's $300,000 in the first APA, and we're actually requesting approval of just a portion in the second APA, which is $200,000. $50,000 is allocated to the social media accounts, which we are requesting approval of the transfer of those today. The remaining $150,000 of value are the tokens. So we're requesting approval of the first APA, which is the VGX Foundation, and then a portion of the second one, which is the SM Asset Ventures LLC, but just to the extent of the $50,000 of value for the social media accounts, not the tokens. We wanted to be crystal clear that the tokens aren't involved. That's why we put it in bold capital letters in the notice of successful bid and in the sale order and in other areas. Does that answer Your Honor's question?
I think so.
I understand it's a little. Ideally, the full 350 value would have been an APA 1, but they have there's two different entities bidding here. You have the entire APA 1 for $300,000, and then there's $50,000 of value in APA 2, which is allocated to the social media accounts, the non-token assets.
All right. Does anybody have any questions about that aspect of the proposed sale? All right. Go ahead, Mr. Goodman.
Your Honor, so. Additionally, I will mention that we are not. Your Honor may recall we have orders from Your Honor to approving the operation of the business until April 25th, as well as an extension of time to assume or reject contracts. The deadline also April 25th. We are not requesting. We're going to let those expire. We are not requesting any further extensions of those times. Ms. Ostro wanted me to make sure that I mentioned that. In addition, we did include in paragraph 16. Your Honor read it. It was in the original. It didn't change in the red line. That we requested authority. That we were authorized after the closing of this sale, assuming Your Honor approves it, to continue to retain contractors on an hourly basis, just for the purpose of liquidation. So we have requested that paragraph. Obviously, if Your Honor has comments on that, we're happy to hear them. But Ms. Ostro wanted me to point that out for Your Honor. And subject to, I don't have anything else. Ms. Ostro may want to add something as well, but that's all I have at this point, subject to your questions.
Well, you submitted Mr. Hurwitz's declaration. Has everyone had a chance to take a look at it? And does anyone object to me receiving the declaration as evidence in support of the motion? All right, I'll receive the declaration for that purpose. Does anyone wish to cross-examine Mr. Hurwitz on any of the factual statements contained in his declaration? No one's interested in that. All right. Ms. Wilden, do you have any concerns about this paragraph 16 in the red line order that was filed at docket 164?
No, Your Honor. If it's just for the purpose of liquidation, we don't consider that operating the business itself. We are looking forward to receiving the operating report shortly.
As am I, yes.
That will be filed today, Your Honor.
All right. Anything else? Mr. Rose, do you have any comments?
I do not, Your Honor.
All right. Mr. Goodman, anything further in support of the motion?
Nothing further, Your Honor. Thank you.
All right. Well, based upon Mr. Hurwitz's declaration and the statements by counsel here today, I'll find that the sale process was a sound exercise of the trustee's business judgment. There's been adequate and reasonable notice to parties in interest as set forth in Mr. Hurwitz's declaration, including full disclosure of the sale terms and the debtor's, non-relationship with the buyer. The sale price appears to be fair and reasonable based upon the determination of the market. And based upon that, I'm ready to grant the motion and sign the order. Ms. Scheuer, do you wish to review and endorse the order before I sign it?
Your Honor, I've seen the revised order that has been docketed. Unless there are further changes from Mr. Goodman, I don't have further comments to the order.
All right, Mr. Goodman, can you get me a clean order to sign then?
Yes, we'll upload that. Thank you, Your Honor. And there are no further changes.
All right. All right, so the motion is granted. Looking forward to the operating report. And anything else to be accomplished today, Ms. Ostro?
No, Your Honor. You'll be seeing a notice. We did convert the crypto assets, and we were able to bring in about $15.4 million that will be coming into the estate, and you'll see that in a notice of our sale. And that's the only substantive update for you, Your Honor. But that'll be shown on the docket shortly.
So was that one lot to one purchaser?
It was, Your Honor.
Remarkable. You see Mr. and Mrs. Spraggs are online listening. Have you had a chance to review their motion that's set for hearing next week?
We have, Your Honor. I've been in communications with Mr. Spraggs. The communication is still open. We have not talked since he's filed the motion, but I'm happy to continue those lines of communication. Our response is due today. We will get that response on file. I do object to the requested relief, but I'm happy to continue to discuss with Mr. Spraggs what information I need in order to further assess his claim.
All right, thank you.
Your Honor, may I say something?
Not at this time. The idea was to make sure that the trustee was aware of your motion and that the parties have a chance to talk before you come to court, which is always a good idea. All right, that concludes the matters for today. The court's in recess. Thank you for your attention.
Your Honor?
Yes?
Your Honor? If I may, I'd just like to request clarification on something. It's with respect to docket number 152, the bar deed order that was entered.
Do you have a question for Ms. Ostro?
For Your Honor.
Okay.
The bar deed order that was entered included a provision at paragraph 7 about claims being confidential and not available to the public unless further ordered by the court. And I just wanted a clarification from the court that this would not preclude the trustees from providing unredacted versions to the SEC. The trustee hasn't cited to a basis to withhold information from law enforcement, and that's not covered by Section 107 of the Bankruptcy Code, under which documents filed in a case are public records subject to limited exceptions. And this confidentiality provision I don't believe there was a request for it made in the motion that was filed at docket 9.
All right. So I'm not going to rule on anything today. If you want to discuss this matter with Ms. Ostro and see if you can come to an understanding, and if it requires any further input from the court, you can bring it to my attention in the appropriate fashion.
Thank you, Your Honor.
Thank you. All right, court's in recess.
Okay, and that does it for that audio recording. Once again, you can find the referral link for Margex down in the description below. Be greatly appreciated. You can check out the platform without making a deposit. And if you make a deposit, again, you can claim up to $10,000 in bonuses. You can learn more about that in the description below. There's also HG Access with over 2,000 members. If you want to see what the benefits are here, you can go ahead and pause the video, or you can check out the direct link for Patreon down in the description below. Thank you guys so much for tuning in. Double shout out thank you to my Patreon supporters. Double shout out thank you to Victor Vegas and Worlds of Rizvi for being higher level patrons. Thank you to my YouTube members for your support as well. God bless, and we'll see you in the next episode.